hello and welcome to Quadcast, Quadrant Chamber's regular discussion and debate forum for hot topical legal issues, where we talk about recent developments in the law, decisions and market developments. This Quadcast is a shipping special, although our subject is by no means confined to shipping. In fact, anti-suit injunctions have a role across all forms of dispute resolution. But as you might expect from a shipping special, we shall be looking at it through the prism of certain types of shipping contract, in particular, contracts of carriage and disputes between ship owners and cargo receivers. We're focusing on this because we've seen an uptick in these disputes in the last 12 to 18 months, and that makes this, we think, a hot topic to discuss on a podcast like this. Now, I'm joined, as you can see, by three of my colleagues, each of who've had their fair share of this recent spate of cases. Gemma Morgan, who I think at the last count had 5 appearances in recent cases. Peter Stevenson, who's not at all competitive, but he puts his number at 6. And Saira Paruk, who's been involved in 2, but I'm sure they were both very important cases. So we will share our collective perspectives on some specific aspects of recent decisions, including questions like when and how is an arbitration provision incorporated into a bill of lading contract, and just what, if anything, can amount to good reasons to refuse release. And we might even pick up 1 or 2 practical issues as well as we go along. But this isn't just about the discussions that we want to have. We're very keen that those of you who are watching us live, feel free to ask any questions you may have. Please do ask those questions, and we will do our best to pick up those and respond to them real time during the course of this podcast. Now, a couple of things we won't be dealing with at length. One is the procedure for obtaining an anti-suit injunction. There's a good reason why we're not. That's because that's already dealt with in a wonderful Quadrant online offering, a qubit 10-minute talk by Tom Macy-Dare QC, who explains exactly what process it is. Can I recommend that to you? It'll be 10 minutes very well spent. You can find that either on the Quadrant website or on our YouTube channel. The other topic we're not going to talk about at length, perhaps to the relief of some of you, will be the impact of Brexit. Although it is right to acknowledge that Brexit has had a very specific impact in this area. At the end of the transition period, the UK were no longer bound by the Brussels recurse regime or the Lugano Convention, both of which prohibited English courts from granting anti-suit injunctions in relation to proceedings in member states. The falling away of that prohibition appears to expand the scope for the use of anti-suit injunctions in a way that hasn't been in place for a very long time. Whether that expansion will take place, what might be the limits, is a subject for another day, or perhaps a subject for another Quadcast from Quadrant Chambers, and I can recommend them that. Another one, it's called No Deal Jurisdiction Enforcement. You can find that in the very same place, on the website or on the YouTube channel. So that's enough, I think, of general introduction and blurb. But before we get on to the detail, just wanted to set the scene a little bit about anti-suit injunctions. I'm sure that most people who are watching are familiar with the relevant principles, but let me take them very quickly just to put ourselves in context. An anti-suit injunction is a standard type of injunction, but granted in a very specific context. The context is that it is prohibiting a party from commencing or continuing proceedings in a foreign suit, in a foreign court. As its name suggests, it prevents participation in a suit. There are 2 broad scenarios in which you obtain an anti-suit injunction. The first, and the one we'll be focusing on, is where the parties have agreed upon a binding jurisdictional arbitration clause, which they have broken, one of the parties has broken, by commencing proceedings in a foreign suit. That's the most typical scenario, and it's the one we'll be focusing on. There's a second type of case where there's been oppressive or vexatious conduct, but we won't be exploring that, so I'll say no more about that. Going back to the first case, the case where there is a binding arbitration of jurisdiction clause, the principles are very well established and can be stated very simply. There are 2 questions. Is there a binding jurisdiction arbitration clause? And secondly, can the defendant establish some strong reasons why relief should be refused? And we're going to be exploring those two questions. Now, in the context of the carriage of cargo, it's not at all unusual for the cargo interest to become party to the contract long after the bill of lading is issued, and actually never to have seen the charter party at all. It's not surprising that when something goes wrong, their instinctive reaction is want to commence proceedings in their home court or the court where the cargo was discharged. They may do so without really appreciating that there's an arbitration or an arbitration clause in place through the charter party. Now, it's obvious that this is fertile ground for anti-suit injunctions. And one question that arises in this context is simply this: has there been an arbitration clause incorporated? And if so, what system of law does one apply to work that one out? Now, I know that Gemma, you've been involved in disputes like this recently. Any thoughts?
Well, thanks, Sam. Yes, I mean, and welcome everybody. Yes, I mean, as you say, a very typical situation which occurs in the international trade context is a contract of carriage contained in the bill of lading, often on a standard form such as Congem Bill 94, and purporting to incorporate into it the terms of a charter party. And it's the charter party which usually contains an arbitration, sometimes jurisdiction, but often arbitration, and importantly, English law clause. You then get a dispute arising between the ship owner as carrier under the bill and cargo interests who, as Simon said, have become holders of the bill. And the question is, what's the correct forum for determination of that dispute? Now, as a matter of English law, the answer to that question is well settled. Where the words of incorporation in a bill of lading include a clear reference to the law and arbitration clause of a charter party, then that clause will be incorporated wholesale into the contract contained in and evidenced by the bill of lading. See the decision, the Rena K. But the question that has come up several times over the past year in a number of recent cases is whether or not it should in fact be English law which determines the question of whether or not the arbitration or jurisdiction clause is incorporated, or should regard be had to the law of the place of residence of the cargo receiver, where that law takes a different view of incorporation. So it's quite common in other legal systems other than English law, a charter party may not be incorporated into a bill of lading if, for example, the receiver is not provided with a copy of the charter party, or there is no express reference to the particular charter party on the face of the bill. So how is the applicable law to be decided? Well, as a matter of English law, we use the Rome Regulation, and Article 10.1 governs the question of the existence of any term of a contract. So here, the question of whether or not an English law clause is incorporated into a bill of lading contract, and that question is governed by the law that would govern if the term was valid. So in our example, if the English law clause is incorporated, an English law would apply, and so you determine it by reference to English law. But the Rome Regulation also has Article 10.2, and you have to have regard to that. And this is where the interesting argument has arisen in a few recent cases. Now, Article 10.2 says that in order to establish that he did not consent to a particular term of the contract, for example, an English law clause or an arbitration clause, a party may rely upon the law of the country in which he has his habitual residence, if it appears from the circumstances that it would not be reasonable to determine the effect of his conduct in accordance with the law that would otherwise apply. So cargo receivers have tried to use Article 10.2 to say that where the law of their habitual residence does not recognise incorporation by reference of a charter party into a bill of lading in the same manner that English law does, then it would not be reasonable to hold them bound by the terms of the charter party, and therefore the English law clause and the arbitration clause, which would be incorporated if English law applied, should be disapplied. Now, so far, it's been given quite short shrift by the commercial court here. In the Ulasoy 11, a case from last year, it was a point taken against me when I acted for ship owners. And Mr. Justice Bryan found that there was no reason to permit the use of Article 10.2 to evade, and that's the key word, to evade the application of English law from the charter party to the bill of lading contract. Now, he said it was reasonable and in accordance with the ordinary expectations of international trade to judge the effectiveness of the incorporation into a bill of lading for the choice of governing law given in a charter party by reference to the governing law specified in that charter party. And the court made clear, and this is a view taken by the English courts, that this method of incorporation is well known to cargo receivers in international trade, and that if a buyer of cargo wished to have control over the terms upon which the carriage contract was concluded, then he could contract on different terms, for example, purchase the goods on FOB terms and arrange carriage himself. So that's the word from the English court so far, yet it's an argument that keeps being run. Now, Peter, I think you've had this argument run against you as well. Where do you see it going? Do you think it's got some merit?
I'm very sceptical that there are any circumstances in which a receiver of commercial cargo in international trade context could persuade an English court that it's unreasonable to apply English law when determining whether the English law clause, which is purportedly incorporated, is incorporated. I mean, the point, as far as I can see, was first taken or first looked at by Andrew Baker in the Joker a couple of years ago. And I think that says something of itself. The law hasn't changed since the 1980s. You know, the test that you take from the regulation also is the same test as applied in the Rome I Convention. And yet the point hasn't been raised or addressed in any of the hundreds of anti-suit cases since then. I'm not sure why the point was taken in the Joker, but I note that the Joker was, the defendant didn't appear, and it's not clear whether the judge raised it or whether it was raised by counsel. But in the couple of cases I've looked at since, or where the point's been taken against me since then, the judge has dealt with it very, very quickly. And I really don't see this as a proper or sensible argument that's going to restrict the circumstances of which you can get an anti-suit, or at least persuade the court that there isn't a binding arbitration agreement. But there is a second point that comes up in the Joker, which is left open by Andrew Baker, which is whether if you could show that the foreign jurisdiction takes a different view of the incorporation law, that might be a strong reason not to grant, or a reason not to grant anti-suit relief. But again, I find that quite a difficult argument. I know it's got some support in some of the textbooks, but effectively you're saying that the English court has decided that you have an arbitration agreement that needs to be protected, but the scope of the protection is dependent on where the contract breaker wants to proceed, which seems to me an unusual conclusion to reach. So I don't know. I know that's a point that was taken in your case as well, and I don't know whether you think that has greater legs.
Yeah, I mean, that was a point that was taken against me. So this is a circumstance where, rather than the foreign law having a view on incorporation, say, you have a mandatorily applicable law in the foreign court, and the foreign court will absolutely take jurisdiction. And there, I think the balance that's been struck by the court so far is to give a significant deal of weight where you have an exclusive jurisdiction or London arbitration clause. But it doesn't stop there. What they will do is, with regard to comity, have a look at what the law is that is being applied in the foreign court, being given weight to. And if there's a public policy reason behind that foreign law, such as protection of consumers or protection of individuals, then and that's the sort of policy that an English court English law would also protect, then the court here might be slower to disregard what the foreign court does. I see you shaking your head, Peter. But
no, I'm not. I'm just not. I mean, I can't see the public policy grounds that are likely to come up in the international trade context. That's the bit. And maybe the insurers' rights is one of them, isn't it?
Yes, and also in circumstances where you have foreign jurisdictions which apply the Hamburg rules, and then there's a question here, we have chosen not to, and then there's a question here of whether that's English public policy or not. But Simon, you've been doing these cases for a while. Have you come across these arguments recently? Is there a trend towards more inventive arguments, do you think?
You're very delicately put about me having done it for a while. Take the cases I've been involved in. I never thought it appropriate when opposing anti-suit injunction to take this point, because I rather share the same view as Peter, and I suspect you do, on the merit of it as a point as to whether there's a binding jurisdiction or arbitration provision. It seems to me that the point is not a good one, but in any event, I was confident that a judge just wasn't going to accept that. But it does seem to me to have a potential role when it comes to look at the question of whether there are strong reasons to refuse relief. If a party has commenced suit without, well, say, completely ignorant of the fact that there is an arbitration provision, they do so in a court which, on the documents, would never conclude that there was an arbitration provision as a matter of law. Well, then all of that seems to me to put a premium on the position of a party seeking anti-suit relief to act promptly to correct the position and make sure that everybody, the foreign court and the counterparty, is aware of the position and therefore is aware of the fact that there is on at least the application of English law, a binding arbitration or jurisdiction agreement. And that's how it fell out in my case, the Kishore. That's how the point was raised in that. And I think it got some legs in that context. And I think, therefore, it really, I think it's best seen in the context of delay type submission. Now, I know, Sarah, you've been doing some cases that involve delay. But do you have a perspective on delay as it's treated by the courts at the moment?
Thanks, Simon. Looking at delay, as Simon alluded to, it's one of the strong reasons against granting anti-suit relief. So the first question is, why does delay matter? Lord Justice Clark in the EcoBank case very much squarely put delay along with comity, linked the two very closely, but also said that other reasons to avoid delay were to avoid prejudice to the parties, to avoid the waste of resources, and also to promote the need for finality. The high watermark of delay as being a strong reason against anti-suit relief was actually Simon's case in the Kishore. That's how it's been regarded. And the test is an application for anti-suit relief should be brought promptly and before foreign proceedings are too far advanced. So the word promptly there is important because it's a standalone requirement. It should be brought quickly no matter the other factors of the case. So it seems that that test means that delay in itself is bad. But if you look at the facts of the Kishore and even the EcoBank case, could it be that in those cases there were other factors which the court considered meant that the delay was particularly significant? So looking at the Kishore in a bit more detail, the delay in that case was of about 10 months. After the anti-suit application had been issued, but before the hearing, the foreign court had actually given a decision on jurisdiction. In that case, there was also a 12-month time bar. So a period of any months would be significant in that context. And also the prospects of success of the jurisdiction challenge in the foreign court was not very high. So it was said to be that there was no objective justification that the challenge in the foreign court would succeed. So on that basis, it was thought that anti-suit injunction application should have been brought because you weren't going to succeed abroad. So it's looking at those factors, and I would consider that the time bar is particularly important. So you could say it's those factors that concerned the court rather than the objective delay in itself. So Simon, that's my view. What do you think of that analysis of the Kishore?
I'm a bit more sceptical of that. I think you don't have to go back very far to see that it's always been stated as a matter of principle that you have to make your applications promptly. And my view of the Kishore, and certainly one or two subsequent cases, is delay has been treated in the fully argued cases as a freestanding limb that can cause can cause relief to be refused simply because you have not acted quickly enough, whatever other factors arise. So it isn't simply that other things have taken place, time bar might have kicked in, there may have been a decision at the foreign court, though there's no doubt that all of these cases turn on their own factors and all would be influenced by that. So it does seem to me that I would say that although subsequent judges have been quite keen to distinguish cases like the Kishore and say, well, actually, they're really all about this. I think that if you go back and look at the cases, they are pure delay cases in their own right, as well as there being other factors. And the other point I'd make is I think when the Kishore was decided, to some degree, it came out of the blue. The zeitgeist, if you like, amongst the judges was that delay doesn't matter too much as long as nothing much has happened and nobody's prejudiced and you've got a reasonable excuse. Even there was a sense that it was okay to have a go in the foreign court and challenge jurisdiction. That was an okay thing to do as long as you weren't doing it on the merits. And I think the judge firmly said no to that. And I think there is a risk, even though the zeitgeist has gone back to where we were before the Kishore, I think there's a risk that in a future case, you'll find another judge who goes back to angelic grace and says, no, delay is enough in its own terms. But having said all that, I know that there has been some recent guidance, Gemma. Could you, from I think Mr. Justice Bryan, I think you were involved in that, weren't you?
Sadly not, but I find it a very helpful authority, and I must say, as someone who's having to deal with the Kishore on a regular basis, and thanks for that, Simon. But yes, no, Mr. Justice Bryan, I think, deals with it really, really helpfully. Sums up the question of delay really well in a recent case, Qingdao Quiquan Shipping, and he says there that the question of delay and the question of comity are linked, and he uses this great phrase: the touchstone is likely to be the extent to which delay in applying for anti-suit relief has materially increased the perceived interference with the process of the foreign court, or led to a waste of its time or resources. So I hear what you say, Simon, about delay being a freestanding issue, but certainly the way in which the zeitgeist is going now, there is a point about what has actually happened during the period of delay that means that the anti-suit injunction, which will otherwise be granted, shouldn't be granted. But Sarah, I think you might be with me on this. You're saying there are more factors. I mean, what other things have you seen the courts looking at?
Well, like you say, Gemma, I think recent cases are moving towards actually analysing what has happened and the effect of delay, rather than just delay itself. So in a case that I appeared in, the Specialised Vessel Services and Mott Marine, Mr. Justice Calver held that a delay of approximately a year was not sufficient to deny anti-suit relief. He analysed the facts of the case quite precisely, and the sorts of things that he referred to were, for example, the foreign proceedings had not progressed very much in the intervening period, so no prejudice had been suffered by the defendant. And I have to say that COVID helped us in that case. The foreign court had not engaged with the substantive merits of the case at all. Any resources wasted by the foreign court had been minimal and only in relation to the jurisdictional issues themselves. Foreign law advice had initially suggested that there was a good chance of success of dealing with the case in the foreign court, even though, as it turned out, that wasn't the case. And also an important point was that the English court was not being asked to second guess any decision of the foreign court. The foreign court hadn't yet reached a decision on the validity of the jurisdiction clause. So it wasn't a case where the claimant was seeking to have a second bite of the cherry. So on those bases, Mr. Justice Calver was able to distinguish this case from ones that went before. And I know that a similar approach has been taken by Mr. Justice Butcher in the VTB Bank case, where again, the precise facts of the case were analysed in that way. So it seems to me that the current position, at least, is even if there has been a delay, it is certainly worth analysing the precise facts of the case to be able to justify that delay. And this may mean getting foreign law advice to justify the approach taken and being quite meticulous as to how you approach it. What really seems to matter to me in these cases is the steps taken in the foreign courts. And I know, Peter, you've got some thoughts on that.
Yeah, I mean, I would also agree with you that it seems to me that the courts now, at the moment, appear to be taking an approach which is slightly different from the one in the Kishore and looking at the steps taken in the foreign proceedings. But I would also echo Simon's warning that it's not entirely clear to me the juridical basis for that slight departure, and you have to be quite careful. But with that in mind, the steps that have been of interest in the cases I've been involved in are the formal steps taken in the foreign proceedings and what's been done, and effectively whether you've submitted or to the foreign jurisdiction. Now, the two most obvious ones are challenging jurisdiction and serving defences on the merits. Now, challenging jurisdiction isn't a truly voluntary, which is the test, submission to the foreign jurisdiction by any assessment. But it doesn't follow that you can simply just challenge jurisdiction, wait and see what happens and go ahead. I think it's quite clear that you need to be acting at the same time in the English, before the English court. You can't say, well, I was taking, or you shouldn't be saying, I was exercising a right in the foreign jurisdiction and then I was going to wait and see what happened. That won't work. Bigger issues arise in respect to serving defence on the merits. You might say, well, serving a defence on the merits is obviously a submission because you're putting before the foreign court the merits of the case. But there are many jurisdictions in which you can't challenge jurisdiction independently of serving a defence on the merit, or if you do, you may lose your right to serve a defence on the merit. And in those circumstances, I think the authorities are quite clear that serving a defence on the merit isn't a truly voluntary submission, and therefore it's something you can do without jeopardising your right to go ahead. And I think that was a point that came up in the Star Moira, at least, which is one of Gemma's cases.
Well, Peter, it's interesting actually, because in the Star Moira, what happened is exactly what you said shouldn't be done. So there, the claimant ship owners had first sought to challenge jurisdiction in the foreign court and got a decision that went against them. And it's only then that they came to the English court and asked it to restrain those proceedings. Now, there was no submission on the merits, and there was less than 2 months between owners getting notice of the claim in the foreign court and coming to the English court to seek an anti-suit injunction. And the judge said there that there was not sufficiently serious delay to refuse to grant relief. He did say specifically that the fact the foreign court has ruled in favour of its own jurisdiction is not per se a bar to an anti-suit injunction from this jurisdiction. That's well established. But he pointed out that, of course, as each stage of the foreign proceedings is reached, more time and costs will have been wasted by the abandonment of those proceedings. And that will potentially make the grant of an anti-suit injunction progressively less desirable and make considerations of comity progressively more desirable. But on the facts of this case, he said the Chinese court had only given a short 2-page judgment on jurisdiction, and it was unlikely that any significant cost had yet been incurred in the foreign court, or any significant judicial resources spent on the matter in the foreign court. And for that reason, the judge was minded to grant the anti-suit injunction. But Sarah, I think you've dealt with a more extreme case, haven't you, of matters in the foreign court potentially affecting the grant of an anti-suit here.
Yes, indeed. Thanks, Gem. When you have when someone needs an anti-suit, it arises in the context where one party normally brings an ex parte application in the foreign court for an injunction preventing the claimant from bringing a claim pursuant to the jurisdiction agreement. So by definition, the foreign court has already decided and engaged with the question of jurisdiction. Claimant then brings an application here for an anti-suit injunction. But unlike some of the other cases, this is not seen to be a case where the claimant's seeking second bite of the cherry, because it wasn't the claimant who put the question of jurisdiction before the foreign court at all. In these cases, the defendant's breach is seen by the English court to have been so egregious, because what the defence is essentially doing is preventing the claimant from exercising their contractual right to bring a claim here. So given that breach, the English court has, in recent cases, exercised its discretion, and the questions of comity seem to fall away. But it's important to note that it's in these cases, in the normal way, the court is focused on the defendant's breach, not the foreign court's judgment. So courts have been very careful not to criticise the foreign court in the normal way. And this is the approach that was taken by Hamlin, Mr. Justice Hamlin, as he then was, in Ecom and Musharraf, and also Mr. Justice Calver in the Specialised Vessel Services case. So I suppose it's important to look at, Peter, the other steps that you could take in the foreign court which would amount to a bar to anti-suit relief. Yeah,
but the point you're making is effectively that where the foreign court has ruled on its own jurisdiction because the other side have progressed, etc., or they've acted promptly, that's not a barrier to seeking anti-suit relief here, and that seems to be the central point. And the same arises, for example, where, for example, a receiver is threatening to arrest a ship in the foreign jurisdiction, or has arrested the ship in the foreign jurisdiction. Now, you can do that, there's no issue with that, but what you're not allowed to do is to seek security which effectively tethers the litigation to that foreign jurisdiction. So that, if you say, for example, I'm not going to release the vessel against an LOU that responds to an arbitration agreement, I'm going to insist upon security being put up that answers to a local court jurisdiction, that would be a breach of the arbitration agreement, probably. And therefore, that's what entitles you to go to the court and seek an anti-arrest injunction using the Calang number 2 analysis. And I think most of us have done that. The problem with doing that is it's not always a very practical option. You have a ship in a foreign jurisdiction under the control, effectively, of the receiver. And if you start going to the court and getting an anti-arrest injunction, you can sometimes stir the hornet's nest and leave the ship stuck in that jurisdiction for quite a long time. And so sometimes or regularly, a ship owner might say the better option for me is to get the ship out and have this argument later. So how do you get the ship out? You issue some security, and then you have negotiations with the other side about the security. And the question that sometimes comes up, or has come up in a couple of my cases, is whether things said and done when negotiating the LOU or the security or the terms of the security itself can be said to have given the impression to the other side that you were happy to go ahead in that foreign jurisdiction. And in those circumstances, whether it would be a strong reason not to grant anti-suit relief in this jurisdiction. Now, the ones I've been involved in have involved LOUs where the parties have been quite quiet about the terms upon which the LOU will respond. And they've inserted clauses that say this LOU will respond to a judgment from a competent court or an arbitration award. And therefore, you've left the trigger open slightly. And I can't see how that could ever really be said to be a representation by the ship owner that they're happy to go ahead in a foreign jurisdiction. You're facing a threatened breach of the contract. You have commercial considerations that want you to get the ship out quickly. And I think you struggle to persuade a court that it was some form of unequivocal waiver to have given security in those terms. I can see slightly different considerations arising if you give an LOU which is responds exclusively to a foreign jurisdiction, which is something that came up in your case, Gemma, isn't it? But even then, I would be sceptical that it was an unequivocal representation.
Well, the judge took the same view, but you're right, Peter. So the circumstance which I had was that the LOU said it responded specifically only to a judgment of a court, of a competent court. But the arbitration clause was what the parties had agreed. And what the judge found in that case, where the argument was made that this was a strong reason not to grant anti-suit relief, what the receivers said was, well, in circumstances, if you make us go ahead with only London arbitration, our security is worthless, the ship's gone, and so we are left in a position where we are unprotected. Should we succeed in our claim, which we think we will do. And in those circumstances, even if there had been an agreement to arbitrate, you, the English court, shouldn't uphold that because of the consequences of doing so. And again, the commercial court gave that very little room. But what was important there, and I think this is probably the takeaway point, Peter, I don't know if you agree, is be careful about how you word the LOU, because in my case, there was an express provision that said nothing in this LOU shall be deemed to be a waiver of any defences, liabilities, etc. of ship owners. So the judge pointed to that and said, well, look, defences, etc. includes the right to argue that there's an arbitration agreement. So it hasn't been waived. But it seems to me, I think there is more scope here for a strong reason not to grant an anti-suit injunction type argument if there is a potential for the party to be left without proper security, particularly if there's any suggestion that during the negotiation of the security, one party was a little bit too keen to get a good deal, if you like. So I don't know what you think, but I think
I've discussed this with Simon the other day, and I think it all comes back again to delay and speed of conduct. And I don't know, Simon, your view, I think, was that really, if you're bringing the point quickly after the vessel's out, you're all right, but leaving it for a long time isn't all right. And is that right or fair?
Yeah, I think it does. We're firmly in the second element, in my view, about whether there are strong grounds to refuse relief, because there's not a problem with the existence of an arbitration provision. And because I think we find it very, very hard to see how anything but the most remarkable form of security could be said to have varied the arbitration clause. It's very, very hard to see it under English law how that would work. So instead, I think it comes back to whether the conduct of the parties in some way means that equity shouldn't come in and grant injunctive relief. But I think probably you need to feed this into issues like promptness and what the foreign court is doing, and whether the foreign court could reasonably be misled as to its role in all of this. So I think if you can characterize the terms of the security as falling within that kind of purview, there's a scope, I think, for argument. But I think typically courts will be, I think, rightly sympathetic to the position of owners who are under some commercial pressure to put up security, and therefore will be very slow to find that the form of the security makes all the difference. It'll be a factor at most, but that would be my take on that. Yeah, I suppose it all depends on how you approach this. You've looked at this in more detail, I think, in some of the cases, haven't you, Peter?
Well, I have, but I agree entirely with what you're saying. I think the real issue is if you've got, I have a case in which the security was put up, no suit was brought for quite a long period of time by the receiver, and they brought a suit in foreign jurisdiction right at the end of the 1-year time bar, and then we sought anti-suit relief saying they shouldn't do so. And the argument was made that we had allowed them to think that the proceedings could go ahead in the foreign jurisdiction, and that as a consequence of doing that, we had allowed the time bar to expire, and they could no longer bring proceedings in London. To which we said it was their fault that the time bar had expired. They hadn't protected time. They brought their suit quite late in the day in any event, and it was on their watch, which was accepted at the interim stage. But I felt that the situation might have been different if we had been the party responsible for the length of time that had taken to bring the suit. And that's where I thought the delay comes in. And it's a similar point. I mean, in those cases, one of the options, I think it was the same in your case, the Kishore, one of the options that was put forward was that any anti-suit should be dependent upon us undertaking not to take a time bar point, which we resisted. But that is an option whereby the court can square that circle. But I don't know, it seems to be slightly arbitrary whether they take that option or not, because Mrs. Justice Cockrell did it in a case not long ago, but it's not done in various others.
Yes, I think, and in the Kishore, the judge expressly rejected the proposition that's what he'd do, but he was obviously driven to his conclusions on discretion for, amongst other reasons, the fact that there was a loss of a time bar. More generally, I'm struck that one of the things, many of the cases we've been talking about today are cases which have been taken place all at first instance, and in many cases without anybody else, any kind of defendant being properly represented. What kind of weight, if any, can we give to these type of cases? Do you have any view on that, Sarah?
Well, I understand that some judges don't give much weight to these cases at all, and you can see why. If you've got an undefended case, what sort of authority can you take from it? But I suppose I would say that in many of these cases, and I'm not talking about the ex parte stage, I'm talking about the inter parte stage, where the other side has had notice of the hearing, but has decided for whatever reason not to attend. The duties on the claimant, the party attending, are higher. You do have to put the other side's case. You can, and within your right, of course, to knock down those arguments, but your duties are higher. So you could say that the case has been properly aired, and it would be fair that those judgments do have, if not the same weight, but similar weight to a normal adversarial judgment. But in any event, does it matter? Because what we're talking about here is the exercise of the court's discretion. So you're very, very unlikely to have two cases that are exactly the same. All you're trying to get from these cases is guidance for the court to see how previous judges have dealt with certain factors. And so whether these cases are authority or not, I think the way to use them is purely guidance. So I'm not sure it really matters, Fun.
I think just sort of, I agree with you completely there, Sarah. I think one thing that's also struck me a lot about this sort of recent run is how popular anti-suit injunctions are as a tool at the moment. And I've been in the position many times, I'm sure you guys have as well, where the first question you ask you want clients to answer you is, why do you want this? Yes, you can probably get it, or you may be able to get it, but why do you want it? What will it do? Is the defendant or the claimant in the foreign proceedings, the defendant of the anti-suit, are they going to take any notice of it? And certainly in the cases I've done, there's been a spectrum as to whether or not the respondent to the injunction has responded or not, or simply carried on. But it seems to me, at least commercially, these are seen as a valuable tool, and people are wanting to come to the English court and get them. I don't know if anyone else has a.
Put your finger on it, though. The point is, it's very hard to know before whether or not it's going to be complied with. I've had cases where the clients have gone to court on the off chance, we'll do it. We have to do something here, so let's go and get an anti-suit, and it's turned out to be effective. Conversely, there are times when you think it's going to be effective because you're against a big international party, and yet they've proceeded, and notwithstanding the injunction in the foreign jurisdiction. Unless you are absolutely sure that it's not going to be complied with, it's a relatively straightforward way of at least taking a step to protect your rights.
I think the penal notice at the top of the order helps. So, if a defendant wants to come to this jurisdiction or not, it can be enforced against them. So I think that goes some way to make them more effective.
But I think also it's worth thinking about what the ship owner in this scenario's other options are. Do they just down tools and say, well, forget it then? Because the easiest way to enforce this particular right or bring it to the attention of the parties will be to obtain an anti-suit injunction, which is a relatively straightforward exercise. And if you don't do that, you risk being treated as if you've submitted to a foreign jurisdiction just by your inaction elsewhere. You risk being exposed down a charter chain to another party who says, well, you should have done that, and therefore we're not going to indemnify you for the costs you've incurred and the liability you've incurred in the foreign proceedings. And in any event, there's absolutely no reason why you shouldn't at least assert those rights for the reasons Peter gives, that somebody might actually comply. So it strikes me that the reason why people do it is because actually it is the best available tool, even if it is not always going to give rise to compliance by other parties. Now, I think we've had some questions in, haven't we, Gemma?
Yes, we have. So the first question, this is a thorny one. Well, not a thorny one, but it's one that crops up every time, and I'll throw it open to the floor. Ex parte or inter partes? How should one obtain one's anti-suit injunction? Thoughts from the floor, please.
I think the answer is it depends on the judge. I've had both. So whether to go ex parte or inter partes. If you go ex parte, you are setting yourself up for definitely having more than one hearing, and you really have to justify why you're going ex parte. And even if you get what you want ex parte, chances are that relief won't last very long. You'll have quite a short return date. So then you'll then have to come back for the return date, and then you'll end up probably with a final hearing. And if there is no real urgency, or there's no real reason not to go into parties first time round, then I think that could be the more efficient approach. But I have to say, I've had judges deal with it differently, in the sense of one has criticised me for going ex parte, one has said, why didn't you go ex parte? So
I think that this is the starting point is obviously you shouldn't go ex parte unless it's urgent, and certain judges will say there's no difference between anti-suits and any other application, and if you're going to go ex parte, you need to show that it's properly urgent, and if it's not, I'm not going to do an ex parte hearing, I'll order an inter partes hearing. Mr. Justice Baker has done that in a case I was involved in. That isn't necessarily unhelpful. If you are facing what may be seen by the other side to be a question of delay, it's quite difficult to go to the court and say, well, I've waited 10 months to do this, but now it's super urgent, so I need to go ex parte. And it's a presentationally easier to say, yes, this is urgent because I don't want things to go ahead too far in the foreign jurisdiction. I don't want to interfere with the foreign proceedings, but it's not so urgent that it justifies ex parte relief. So what I'll do instead is I'll seek an inter partes hearing on an expedited basis or service by alternative means, and go that way. And that has the upside of, one, reducing the number of hearings that you need to do, and two, just making it slightly kind of reducing the stark contrast between your kind of potential delay and the urgency you now say it infects the rest of the proceedings. So that seems to be a way forward. Another way forward is to ask for the inter partes hearing to be treated as a final hearing, so that can reduce the scope. But again, the appetite for courts to do that it seems to be dependent on the judge.
Yeah, I mean, certainly my view is that the better way is if you can go into parties. There may be a reason why ex parte is important. For example, if there's a risk of an anti-suit injunction being sought in the foreign jurisdiction if you tip off the other side that you're going. But absent that, my view is that inter partes is better, not least because it reduces, Sarah said, the cost of the number of hearings that you have to do. And if necessary, you can ask for an expedited timetable if there is some urgency in the foreign jurisdiction. One question we've just had in, what factors and circumstances are causing this stream of anti-suit injunction cases? And is this increase likely to continue? What do you anticipate? It's not because Quadrant Chambers is doing a buy one, get one free. I will just say that. But what reasons do you think are causing this?
Well, for my part, I don't think there's any particular obvious underlying trend. I don't think there are more disputes between cargo receivers and ship owners than there would have been 24 months ago or 3 years ago, anything of that kind. But I think there is a sense that the anti-suit injunction is a readily available tool. It is one that the English courts will grant readily. It's quite, you need quite dramatic sets of facts for it to be refused once you've established agreement. With the consequence that I think ship owners have seen this, or parties in their position, as a relatively straightforward way to be able to enforce their position. And I think the zeitgeist we've been talking about is something that's fed a little bit into the amount of cases, of applications we've seen. It's not perceived to be a terribly high risk option, and it is an option that's perceived to be valuable. So I think that's one of the factors. There may be others that people are conscious of.
I have no idea is the short answer, but I wonder whether, I wonder whether it might also reflect a greater willingness on the part of receivers to seek to go ahead in a jurisdiction that is not the contractual one, or less deference being paid to London arbitration agreements in certain jurisdictions around the world. I don't know. Maybe you've been around longer than any of us, Simon. Was there greater deference previously to jurisdictional arbitration agreements, potentially?
You keep reminding me I've been around longer. However, I don't think the deference has changed at all. I don't think those dynamics are any different. If there are a change in dynamics, I think it's the anti-suit injunction is no longer seen. Despite, look at the old cases, the courts are told to use it with caution, that it is some sort of remedy that is to be used unusually because you're interfering with foreign courts. That's not a language that modern judges, they'll mention it, but they don't act as if it really matters. And I think that's a serious factor behind this.
Yeah. And I also wonder as well, I mean, we're 25 odd years on from the Angelic Grace. I wonder if sometimes it takes a period of time for a remedy, in the sense that this was a remedy that was loosened up and liberated from its previous sort of confines, if it takes sometimes that long. I mean, also one thing I've noticed, I don't know about you, but I've noticed that often it is lawyers in the foreign jurisdiction, is the lawyers in the place where the foreign proceedings are being commenced in breach of the English arbitration or jurisdiction clause, saying, well, what about an anti-suit injunction? So there is more awareness in the foreign jurisdiction that the English court can and will offer that. So I wonder if that has it. Now, just one question that's come in on the question of LOU. There are actually quite a number of questions. We may not have time to do all of them. But the first one, if the local court arresting a vessel only allows release against an LOU, providing for their local law to apply to the claim-bring board, and the ship owners club provide that LOU, could that be prejudicial to a subsequent anti-suit? So that's a question for you there, Peter. So if the local court will only release the vessel if the LOU applies for local law to apply.
Well, those are quite close to the facts in the Calang number 2, where it was Senegal, I think, or court that would only release against local security. And the short answer is no, because that is the fact that you've arrested in those circumstances. I think it was Hurst who said that it would constitute a breach of the arbitration agreement, and so you would effectively be arguing that you should be disentitled to enforce your right to anti-suit relief because the counterpart has breached the arbitration agreement by forcing you to put up security. So in short, I don't think it would prejudice your right to get an anti-suit injunction. what you should do to make sure that it doesn't do that is to offer security before, which answers to the arbitration agreement. So if you have set up a paper trail, you say, we will put up an LOU that answers to London arbitration in that scenario, and that is refused, and then the club has no option but to put up security that answers to the local one, I don't think there could be any argument then that you've done anything or said anything which undermines your right to enforcement. So that's how I would do it. But even if you didn't do that, I don't think it would preclude you from seeking anti-suit relief.
I would strongly agree with that. I would say that the more, if it's in fact the case that you can only have valid security if it answers to a local court, the more it's obvious that the actions of granting that security is involuntary. You haven't agreed to do it. You haven't volunteered to change your position. You had no option. So actually, I think that kind of scenario is a scenario where it's very unlikely that the LOU would undermine your position or would undermine your rights to obtain an anti-suit.
Right, because going back to what you were saying earlier, Simon, about, this is an injunction, should equity intervene? When you're looking at strong reasons, whilst it's not in the test, often it is looking at whether or not the applicant for the anti-suit injunction has done anything, which means that its otherwise solid right to have its dispute litigated in a particular forum should be lost in any way. And another question we've had in on the same vein is that in certain jurisdictions, a ship owner might not be able to negotiate the security wordings itself. How are they then supposed to avoid the waiver argument? And the answer to that is, again, if you have no say, if the matter in terms of security is involuntary, then you won't be taken to have done anything or said anything which could be amount to a waiver of your rights. You're saying, no, I've got my rights and I want to rely upon them. But nevertheless, I've had to do something elsewhere. But there's no reason to suggest that that's contrary to that.
Any points of voluntary or not, and paper trail. So make sure you're clear as to what you asked for, you offered, and that you've always acted in line with the contractual agreement.
And we're going to have to, I think, just looking at the time, I'm going to have one final question, and it's throwing open the debate which we started with. So Peter, I'm going to direct this one at you first.
I think you're saying, is it fair to grant an anti-suit injunction where there are statutory rights in the foreign jurisdiction which entitle the other party to proceed in that jurisdiction?
Yes.
The short answer is, I think the angelic grace says it is fair, because the English court will address it through the prism of English law, and as a matter of English law, the parties have, independent of any statutory rights, agreed to this jurisdiction or arbitration agreement, and therefore it is fair to hold them to that agreement. So that would be the kind of the short answer. Similarly, the fact that a foreign statute purports to interfere with English contract law rights is not of itself a reason that the English court should consider for refusing to exercise those rights. So, for example, the fact that a foreign jurisdiction would give a party a right to go directly against an insurer who's been subrogated to a claim a right to proceed in the foreign jurisdictions may mean that it's justifiable or understandable why the insurer has purported to commence proceedings, but the English court's not going to say that that is something that needs to be respected. The English court will say, as a matter of English law, the subrogated insurer must exercise its rights consistently with the rights, the derived rights that it has. Now, this plays back into the question about conflict of conflicts that we first talked about. It might be said that that is another factor that should be taken into account when dealing with discretionary whether the release should be granted. I said already that I don't think that's very persuasive, but I'm very conscious that, for example, Thomas Raphael has written a long article saying it isn't fair and the English court's jurisdiction is exorbitant. And I know Mr. Justice Baker and Thomas Raphael are going to have a combar debate about this. So if that is a point that the question is interested in, I would, although it's not a Quadrant Chambers event, I would recommend signing up to the combar debate on that topic, because it is a more live one and one that there are competing views on.
And I would add that it seems to me that those sort of considerations tend to have greater weight in circumstances where there isn't an agreed arbitration or jurisdiction clause. When you're in the exorbitant or oppressive, I think then arguments about mandatory provisions in foreign laws really do carry a lot of weight, even in the English courts. The English courts tend to say that where the parties have agreed what law will govern their contract and what forum will decide it, well, then they've made those decisions and they must live with them. And they can't be allowed to effectively change that by going and asserting a right that only really exists somewhere else. So I think that's really why English courts perceive that as fair. I think that was our last question, wasn't it, Gemma? I think
it was, and just to pick up on that, because the point about fairness there goes to exactly an English court as an English law approach views the consignee as having agreed, and that's how the English law approaches things. But the minute you step outside from looking at it from an English law point of view, you can see that there is an argument that there has not been an agreement. And I think why it matters and then why this question needs more consideration is not just in the context of an injunction against, say, a consignee cargo receiver bringing proceedings in its home jurisdiction, but the question which follows on from a finding that there's breach of an arbitration agreement, which is an entitlement to damages. And we haven't covered that today, but that, it seems to me, is an important point, because then you're going a step further and saying, well, there has been a breach of an arbitration agreement, you're entitled to your injunction. That also gives, in this case, the ship owner the entitlement to sue for damages. In that circumstance, I think it's a lot harder, but that might be a question for another day.
That's a question for Simon Croall. That's one of your cases.
I've done a case on what the law of damages in relation to that, and I can promise everybody it's definitely a question for another day and another podcast, because we can spend at least 1 hour on that. But let's park that to another day. I think that's everything. Can I thank my panelists, Gemma, Saira, and Peter, for their input, and can I thank all of you for taking part, who are there on real time, and everybody who comes on YouTube to watch this. But we've enjoyed sharing our thoughts with you, and I hope you're all a little bit better informed as a consequence. So thank you very much, and whatever your time zone is, goodbye.